Guys, it's Mo from Mo in the Deep End, and I promised a big Delphi update. There are several things going on, and so last night I did a pretty long video about the affidavit that kind of goes over everything that Judge Gull has and hasn't done in the defense's eyes that would put her in the position to be disqualified, showing bias and prejudice against the defense team. Now, the same day or the day after that was filed, the state prosecuting attorney Nicholas C. McClelland, who I lovingly call Miami Vices, let me see if I can pull a picture up of him because I think you'll see why. You know, nothing like being prepared. You know, me being prepared, that would be amazeballs, but that has never happened in my entire life. So let's get a picture of Miami Vices. Here we go, in all his glory. Let me see if I can stop screen, present, share screen. Nicholas McClelland. As you can see here, someone is trying to pull a Don Johnson from Heartbeats right here. Let's pull this up. Oh, for the love of Cheetos. Yes, sir, this is not a heartbeat. This is not anything. I am stop screen, present, share screen. Look, sir, this is not, you know, we are not doing shoeless stuff and, you know, I can feel it coming in the air tonight. Phil Collins is not on the menu. Anywho, I'm going to stop making fun of his appearance and get into the actual story here. So, while this was happening, while the defense was preparing its motion and affidavit to get Judge Gull yeeted from the case, it was, you know, a hell nah, if you will. That's a term of art, if you will. You know, as a layperson, the state decided to go ahead and move for contempt. And this is all going over the fact that Attorney Baldwin accidentally sent an email to the wrong Brad. So the state is contending that Attorney Baldwin violated the gag order. Now, you want to talk about petty high school BS, this would be petty high school BS, in my personal opinion. Again, I am not a lawyer. I am not even a lawful law pro se constituent like Mr. Darrell Brooks. But this seems like a desperate Hail Mary of stupidity to me. So this is verified information of contemptuous conduct. Comes now the state of Indiana by prosecuting attorney Nicholas C. McClelland, or Miami Vices, and brings to the court attention as an officer of the court verified information of contemptuous conduct. This man, again, do we want to talk about contemptuous conduct when you withheld exculpatory evidence as related in or relayed by the defense team in Judge Gull, or the affidavit to have Judge Gull removed? Do we really want to start throwing stones, sir? Because the fact that you have done this, do we really want to start throwing stones about how ethically everyone's behaved? Because I don't think we're going to like the results if we start throwing mud. But this, it seems like it's a bold move, Cotton. Let's see how it works out for them. I feel like I'm on ESPN The Ocho right now. Verified information of contemptuous conduct by defense counsels Bradley Rossi and Andrew Baldwin pursuant to IC 34-47-3-5 subsection D. The state would ask the court to order Bradley Rossi and Andrew Baldwin to appear before this court and show cause if there be any reason they should not be held in indirect contempt for violation of this court's order, the state would ask the court to consider the following information. 1, that both Bradley Rossi and Andrew Baldwin were appointed by this court to represent the defendant herein as public defenders on November 14th, 2022. 2, that a hearing was held on November 22nd, 2022 to resolve preliminary matters. The same day, the state of Indiana filed a motion for an order prohibiting the parties, counsel, law enforcement officials, court personnel, coroner, and family members from disseminating information or releasing any extra judicial statements by means of public communication, commonly referred to as a gag order. 3, the court took the state's motion under advisement, but in an in-chambers conference, defense counsels Bradley Rossi and Andrew Baldwin refused to agree to the state's motion, stating that such an order, i.e. a gag order, was unnecessary because they had no intentions of discussing this case in public. 4, that on December 1st, 2022, the defense put out a press release that included extra judicial statements by means of public communication that commented on the case to the public and media, including commenting on the investigation by law enforcement, the evidence discovered against the defendant, and presenting evidence they believe proves the defendant's innocence. The information released would have been in direct violation of the quote-unquote gag order that the defense would not agree to and which the defense stated was unnecessary because they were not going to discuss this case in the public or the media. The press release is herein attached as State's Exhibit 1, quote-unquote. 5, that press release contained multiple comments of a kind presumed to have substantial likelihood of materially prejudicing an adjunctive proceeding in this matter. 6, that the court entered an order on December 2nd, 2022, granting the state's motion for order prohibiting the parties, counsel, law enforcement officials, court personnel, coroner, and family members from disseminating information or releasing any extra judicial statements by means of public communication in whole without a hearing. The order directed attorneys not to comment on this case to the public or media directly or indirectly, by themselves, or through any intermediary in any form. The court reminded counsel at the time that they were bound by rules of professional conduct, Rule 3.6, about trial publicity. This order is commonly referred to as a quote-unquote gag order. The court commented that this order was put out in response to the press release by defense counsels Bradley Rossi and Andrew Baldwin. This guy sounds like a schoolmarm. He sounds like Milhouse. Like, oh my teacher, or oh my gosh, do you guys remember Recess? It was a cartoon. He sounds like Randall. I'm going to call you Randall from now on. Miami Vices is a little too cool. You are now Randall from Recess. 7, that sometime in December of 2022, defense counsel Andrew Baldwin violated the court's gag order by sending an email to Brandon Woodhouse containing an outline of discovery, including the names of juvenile witnesses. Brandon Woodhouse is not an attorney on this case and not involved in the case in any capacity. 8, further, defense counsels Bradley Rossi and Andrew Baldwin failed to notify the court or state of the dissemination of information in this case to an unauthorized recipient and intentionally withheld that information from the court and state, asking Brandon Woodhouse to delete the email. Again, this was unfortunately like when you push B and, Bradley, Brandon, and Butterfingers can pop up in your autofill. Unfortunately, because Brandon Woodhouse used to work at, from what I'm understanding of the story, and I could be wrong, so fill me in the comments, but what I'm understanding of the story, because Bradley Woodhouse used to be an associate with Andrew Baldwin, it accidentally, instead of going to Brad Rossi, went to Brandon Woodhouse, and it was supposed to go to Brad Rossi. Now, again, they asked him to delete it. 9, that this quote-unquote leak of information was not discovered till the state uncovered it on Brandon Woodhouse's YouTube channel in March of 2023. Further, it was discovered that Brandon Woodhouse has disseminated the information to several other people, and his YouTube channel has been viewed by multiple viewers. This dissemination of material from the case is a violation of the gag order, and that directly relates back to the defense counsel. 10. That on February 13th, 2023, the state filed a motion requesting a protective order governing discovery in an effort to prevent the defense from disseminating evidence in this case to people outside the case and or to the public. 11. That on February 17th, 2023, the court granted the state's motion and put in place a protective order setting forth very strict rules to prevent dissemination of discovery in the case to the public or anyone not involved in the case. 12. That in October 2023, the state was made aware by families of the victims that crime scene photos were leaked to the public. Indiana State Police began an investigation into how the photos were leaked. It became immediately obvious that the leaked photos came from the defense. On September 18, 2023, the defense filed a Frank's motion with a memorandum in support. The memorandum described the crime scene in gory, graphic detail. As part of that memorandum, the defense attached exhibits that were provided in hard copies to the state and the court. Some of the exhibits were side-by-side photos that the defense created and photos of the crime scene that the defense had altered. These photos were the photos that were leaked to the public. 13. That investigators were led to a podcaster who said he got the photos from an individual he knew. The investigation led officers to determine the podcasters got the photos from a man that he knew who got them from Robert Forston. Robert Forston received the photos from Mitch Westerman, who is tied to the defense. 14. That on October 10th, 2023, defense counsel Andrew Baldwin stated on a conference call with all parties that a trusted confidant by the name of Mitch Westerman stopped by his office to visit, snuck into his conference room where all the discovery in this case was being held unsecured, and took photos of crime scene pictures. Defense counsel Baldwin stated that this occurred without his permission and the pictures were stolen. Ironically, this was hours after investigators spoke to Forston and determined that Mitch Westerman, leaked the photos, and he was the connection to the defense. 15. The investigation by the Indiana State Police revealed that Mitch Westerman previously worked for Baldwin and was a person Baldwin trusted. In an interview with the Indiana State Police, defense counsel Baldwin admitted that he voluntarily gave Mitch Westerman a copy of the Frank's memorandum to review. Now, I would think as a lawyer, if you are now, I mean, again, I am not a lawyer. I think I've said this a gajillion times. But I would think if you are coming up with a huge, enormous, kind of explosive memorandum, you might have another lawyer who's outside of the case look at it and see, hey, does this look normal, or does this look, appropriate? Would you read this over and see what you think about it? But maybe I'm wrong. Maybe that's totally inappropriate. I don't know. Tell me if I'm wrong somewhere. Defense counsel Baldwin also stated he gave the Frank's memorandum to another civilian to review. The Frank's memorandum and exhibit contained protected discovery information that included very sensitive crime scene photos that were quote-unquote leaked by Mitch Westerman. Specifically, the investigation revealed that Mitch Westerman gave the photos to an individual named Robert Forston, who then passed them on to individuals who distributed them throughout the internet. 16. That October 12, 2023, defense counsel Brad Rossi submitted a letter to this court admitting both he and defense counsel Andrew Baldwin had agreed to store the discovery in a conference room in defense counsel Baldwin's office. Further, defense counsel Rossi admitted that Mitch Wasserman, I want to call him Wasserman, I don't know why, Westerman, had access to the conference room and took photos. Finally, defense counsel Rossi admit that it was negligence on the part of defense counsel to allow Mitch Westerman alone in the office where sensitive discovery material was stored. See Section 4 of the letter filed in the court. Then in Section 10 of the same letter, defense counsel Rossi accepts responsibility for the lax in security that caused the photos to be leaked, admitting to the court that they were in indirect contempt of the court's orders. 17. On October 18th, 2023, Mitch Westerman submitted an affidavit to this court stating that he in fact went into the conference room of defense counsel Andrew Baldwin and took pictures of discovery evidence without the permission of counsel Baldwin. 18. The investigators were able to retrieve messages between Robert Forston and another individual that showed Robert Forston had detailed real-time knowledge about when the evidence was submitted to the defense and contents of the evidence for weeks before the photos were leaked. Forston also knew the actions the defense took in trial preparation, leading law enforcement to believe that this was not a one-time act of one person, but a consistent quote-unquote leak of information and discovery in the case. The investigation showed that Westerman would get information about the case and give it to Forston, who would distribute it to other individuals. 19. That investigators attempted to interview both Mitch Westerman and Robert Forston, each of which declined. You can decline, a criminal investigation? Okay. 20. Shortly after investigators attempted to interview Robert Forston, he took his own life. And I'll stop here to say to the family of Robert Forston, I'm sorry for your loss. Self-deletion, things like that. I am very sorry. To lose someone at any time is hard. An investigation into that death led law enforcement to find out that shortly before his death, he had expressed concerns about the open investigation concerning the discovery leak in this case and stated to someone that if he just came clean, all this would go away. 21. That a search warrant on the iCloud account of Mitch Westerman revealed screenshot photographs of conversations between Mitch Westerman and defense counsel Andrew Baldwin, wherein they candidly discuss the Richard Allen case and candidly talk about the court and state, displaying a free flow of information that is protected by the court's gag order and order protecting discovery. 22. The investigation shows that defense counsel failed to secure evidence and discovery materials in this case, specifically graphic crime scene photos which were distributed to the public and put on the internet in violation of the court order dated February 17, 2023, and evidence supports a conclusion that the disclosure was ongoing. 23. That on October 19th, 2023, again at the hearing held on October 31st, 2023, David Hennessy, attorney for Andrew Baldwin, suggested to the court that both attorneys be sanctioned for their actions. Those sanctions have yet to be addressed. 24. The state was notified in the beginning of the leak by the defense by the families of the victims. Since that time, the state has had the opportunity to talk to the families of the victims about the photos and information that was leaked. The amount of harm and re-victimization that this has caused the families of the victims is unmeasurable and incurable. I will stop here because what was done, what these people did by putting graphic and these pictures, look, my one fear about being part of a jury pool that may or may never be called in my county is that watching these trials is hard enough, and I don't have to see these horrible, horrible pictures. I can only imagine these families, because beyond the, crazy shenanigans of this story, beyond all of this, at the very heart of it are these two little girls who just wanted to have fun on, a warm February day before Valentine's Day. And the heartbreak of having these pictures and these trolls, these gnomes, these absolute, vampires on the internet, using that for clout and and whatever. It's gross and it's wrong. I don't care who you are. It's gross and it's wrong and it should never have happened. 25, the press release and 2 occasions of leaked information show a trend by defense counsels Brad Rossi and Andrew Baldwin of not being completely honest with the court, violating the court's gag order set in place to protect the integrity of the case and failing to comply with the protective order that was put in place to protect discovery in this case. Wherefore, now comes the state of Indiana by prosecuting attorney Nicholas C. McClelland and swears under penalties of perjury that the information above is true and accurate to the best of the state's knowledge based on filings, personal knowledge, and police investigations. The state asks the court to issue a rule to show cause order based on the information and set the matter for a hearing and order attorneys Brad Rossi and Andrew Baldwin to appear and show cause, if there be any, why they should not be held in contempt by this court. So that's one part of what we have going on. So I find this to be a bit desperate. This is the press release that I've obviously gone over before. This is the press release that the defense team put out that kind of necessitated the gag order. And this is part of the, exhibit that Randall, Prosecutor McClelland put out that, said this is, they pinky promised they weren't going to, put anything into public, and they went back on that. So that's part of what's going on. Now we are going to stop this and we are going to go into, let me see if I can open this up. In Biggin, one day I'm going to be Neo. I mean, not today, but someday. Oh. Okay, now this is the response from the state. Again, I know you are all aware of the fact that now 2 sets of attorneys have asked repeatedly that Mr. Allen be moved from the Department of Corrections to a local jail so that he is for the very fact that he is a pre-trial detainee, and most of those are held in county jails, but also for the ease of being able to conduct a defense case. I mean, they had problems in Westville with the prison guards, almost stopping any actual unfettered talking to their client. And at Wabash, the new defense attorneys could barely talk to their client because they were in a daggone prep kitchen. Now, the state is going to respond to the motion for transfer. Now, I do believe that this is from the new defense. So this would be from attorneys William Labrado and Scremin. So this was going to be prosecuting attorney Nicholas McClelland, definitely saying that they're super-de-duper lying, all the lying liartons. Now comes the state of Indiana by prosecuting attorney Nicholas C. McClelland and respectfully informs the court that the state has no preference where the defendant is held pre-trial, but the state believes it's in the best interest of the case as an officer of the court to inform the court of the exaggerations and inaccuracies outlined in the defense's third motion to transfer. The state would ask the court to consider the following. 1, that the charges were filed against defendant Richard Allen on October 28th, 2022 for 2 counts of murder in violations of IC 35-42-1-1, subsection 2. 2, that Carroll County Sheriff's Department, let me see if I can imbigonate. There we go. Requested that defendant be transferred to the Indiana Department of Corrections for safekeeping and said the request was granted. Now, the request was granted and then that judge promptly recused himself. 3, that the defendant was transferred to Westville Correctional Facility on November 3rd, 2022. 4, that the defense filed an emergency motion to modify the safekeeping order on April 5th, 2023, which was denied. 5, that the defense then filed a motion to reconsider and a request for due process hearing on May 3rd, 2023. 6, that a hearing was held after which the court denied the defense's motion to modify the safekeeping order, stating that the allegations advanced by the defense were not supported by evidence presented. The court added that the defendant was being treated more favorably than other inmates housed at the Westville Correctional Facility. That was the hearing where the witness that had written the letter stating that Richard Allen was being abused did not want to show up at the hearing, so Judge Gohl unilaterally decided that he didn't have to show up and told the defense that she just said he didn't have to show. Now, and she made the decision that he's been, treated great. 7, the court made a finding that it is reasonable and necessary to house the defendant at Westville Correctional Facility to ensure the defendant's safety to prevent seriously bodily injury to himself. 8, that the defense then filed a verified motion to immediate transfer of custody, alleging additional mistreatment of the defendant at Westville Correctional Facility. 9, that once again the court stated the defense's assertion were factually inaccurate and were refuted by evidence that the state provided, therefore denying the motion. I'm going to go ahead and say Judge Gohl didn't even read the daggone thing. 10, the Department of Corrections then transferred the defendant from Westville Correctional Facility to Wabash Valley Correctional Facility. 11, that new counsel for the defendant has now filed a third motion to transfer. 12, that the state has no opinion where the defendant is housed during the pendency of this case as long as he is kept safe. However, the state believes that it is imperative for the court to have accurate information in order to make its decision, which is lacking from the defense's motion to transfer. You were there? Question mark? Randall? 13, that counsel for defendant referenced the emergency motion to modify safekeeping order filed by prior counsel and how they find allegations in that motion meritorious. 14, that the motion has already been litigated at length and the court found the allegations outlined in that motion were without merit. The judge is biased as hell, Randall. She's on your side. 15, counsel references a letter written by inmate Robert Bastin at Westfield stating that the defendant is being mistreated as fact to be taken as true. However, prior counsel subpoenaed this inmate to testify at a hearing and the inmate refused to leave his cell to attend the hearing. The state has documented Robert Bastin's history with the court in prior hearings and filings with the court. The allegations by Robert Bastin are not reliable evidence provided as sworn testimony, nor has he been subjected to cross-examination. Wait a minute, so are you saying prison snitches aren't honest? Because I think you might have to let everyone that you've, convicted on prison snitches out. I know you can hold two very different thoughts at the same time because you are the state and you have that power, but I'm just saying, prison snitches lie. 16, the counsel for the defendant reasserts that the defendant is being mistreated by guards at Westville who practice Odinism. 17, again, this issue has already been addressed in a previous motion and was found to not have merit, and the motion was denied. 18, the defense then make the allegation that the defendant was denied recreational time and showers at Westfield Correctional Facility. 19, the defendant has never been denied recreational time or showers at Westfield Correctional Facility. Oh, did you ask the guards? And they said, no. And you said, okay, thank you for, we just asked. Because guards never lie. 20, the defendant was moved from Westfieldville Correctional Facility to Wabash Valley Correctional Facility. He made statements about self-deleting. As a precaution, he was examined by mental health I only speak one language and sometimes I can't do that right. Mental health professionals, and they determined he should not be given recreational time until they can be sure he would not hurt himself. Once he was on very serious watch, his recreational time resumed. Sure, Jan. 21. That counsel next complained that check-in process at Wabash Valley Correctional Facility is too burdensome and time-consuming. 22. The state was able to review footage from counsel's visit with the defendant at Wabash Valley Correctional Facility. Counsel for the defendant arrived at the facility at 12:35 p.m. and were processed to visit their client by 12:58 p.m. That wait time was extended on this date due to a power outage at the facility, but in total only lasted about 23 minutes, not nearly the 1 hour alleged in the proceedings, or in the pleadings, sorry. 23, that the facility typically does not allow face-to-face visits, but did accommodate the counsel and set up the defendant in a special room, seated behind a door that was see-through and had a slot where documents, papers, or whatever could be passed through back and forth. See photographs attached as States Exhibits 1 and 2. 24, that a surveillance camera was present in the room and records movement only, no audio recording. The only thing that was recorded from this visit is when counsel entered the room and when they left the room. That to state's knowledge, any jail that attorneys visit to meet with their clients is video recorded or monitored in some fashion. That is to protect the attorney and the defendant. 25, that neither attorney brought a computer with them to provide the defendant with review of discovery or video or audio discovery even after the DOC made accommodations for them to do so. 26. The defense were told by legal counsel for the DOC that if they needed anything additional to meet with their clients, just ask and accommodations would be made for them. Again, sure, Jan. 27. That each request that counsel for the defendant have made of Wabash Valley Correctional Facility has been granted. 28. All this is to say that the allegations that the defense outline are exaggerated and misleading. They were able to meet with the defendant 6 feet away through a door. Show him discovery in whatever format and meet with him in an effective way. Yeah, sure. This seems more of a motion about convenience for them instead of a zealous representation of a defendant. I thought you had no opinion. I thought you were Switzerland in this. You give no craps where this guy is, just as long as he's safe. So why are you so salty? Why are you like, nuh-uh, it only took him 20 minutes, not an hour. I done trapped. Randall. 29. The state pulled the records from Wabash Valley Correctional Facility, spoke to legal counsel for the Department of Correction, and reviewed the video surveillance of Wabash Valley Correctional Facility, and the allegations put forward by the defense are inaccurate. 30. That the defendant had a tablet in his cell and he can communicate with his counsel at any time and has had said tablet since he's been there. 31. In addition, since the motion has been filed by the defense, the DOC has set up video conferencing so that the defendant can now meet with his counsel via video. 22. That the defendant has commissary in his cell where other inmates do not. 33. That the defendant is being treated far better than any other inmate in the DOC. Yeah. He's presumed innocent, and he's in solitary confinement. Yeah. 34. The state also spoke to Sheriff Dan Mauer of Adams County, and he is not willing to accept the defendant into his facility. He does not have sufficient space or accommodations to house the defendant. The Adams County Jail is also doesn't have mental health professionals available to address the defendant's mental health needs. 35. The state spoke to Sheriff Troy Hirschberger from Allen County, and he is willing to accept the defendant into his facility, but only at the expense of Carroll County. However, Allen County Jail is currently overcrowded, and Sheriff Hirschberger would have to make special accommodations to house the defendant. In addition, Allen County Jail does not have face-to-face visits. You are such a smarmy bastard. All visits are done via video, including attorney visits. 36. That the defense continues to make unfounded accusations supported by insufficient proof. 37. That Carroll County Sheriff's Department does not have the manpower to transport the defendant or room to house the defendant in a manner that ensures his safety. Wait a minute. So it's harder for the sheriff's department to haul this man from Wabash than it is from Allen County, just a county over. Please tell me how manpowery it is to haul him from near 300 miles away. It's much less manpowery than from Allen County. Please tell me the mental gymnastics. 38. That Carroll County does not have mental health counselors or counseling to address any self-deletion concerns that have been ongoing. 39. That once again, for the third time, the colorful, dramatic language used by the defense is an attempt to curry public favor for their client and try this matter in the public eye instead of the courtroom, as has been a repetitive pattern in this case. 40. That again, the state has no opinion. I'm sorry, it seems like you have a lot of opinions. Nope, it seems like you have a lot of opinions, Randall. Where the defendant should be housed, but waiting trial, but the state does take offense too. Once again, filing a motion with this court that's full of inaccuracies and allegations not supported by sufficient evidence in order to influence this court to move the defendant. 41. The state has no objection to the defendant being moved to a facility within the Department of Correction, but the court has already addressed that issue in previous orders. 42. That the defense is consuming the limited resources of this office and the court with repetitive motions and that lack any factual basis. Piss off, Randall. Wherefore now comes the state of Indiana by prosecuting attorney Nicholas C. McClelland Randall and files their response to the defendant's third motion for transfer and would ask the court to consider the same when making its decision for all other just and proper relief in the premises. How about you stuff it, Randall? How is it that so you're saying that okay, Rossi and Baldwin were cooking up this scheme to make Richard Allen look defenseless and helpless. And Labrado and Scremin, who really didn't like Rossi and Baldwin and really didn't want to talk to them or anything, they were kind of like, talk to the hand. But somehow they cooked up this, PR scheme together, and they got a private investigator to commit perjury too. What the actual Schnell? Sir, I can't with you. There's a little bit more, but this video is getting a bit long, so I will make another video, but, yeah. This is all dumbness. Look, guys, I feel terrible for the family that those photos were leaked. I can't imagine losing your child and the violence, the absolute monstrous way that they were taken, and then to have that used for clout, used for clicks, used for subs. I mean, What makes you that desperate for popularity that you would do that? I have no idea. I can't imagine. But I don't know that the fact that something auto-populated rises to contempt, and the fact that someone's friend betrayed them means that's contempt. But again, I'm not a lawyer. And then for Mr. McClelland, Randall from, Recess, to basically say that 4 lawyers, 2 groups who basically didn't like each other, and 1 private investigator all colluded together to basically tell big old fibs and perjure themselves to the court in order to, lie on the Department of Corrections so that we could waste precious, precious resources for a judge who apparently doesn't read any motions and or approve any invoices. I have no idea. The ridiculousness of this case is just dumb enough to be real. And at the bottom of this are 2 little girls who are screaming for justice. And we have this guy just with all the stupid. It's all the grandstanding, it's all the dumb, and I just want these girls to get justice, and so many of us do. And it looks like kabuki judicial theater to those of us who don't have a law degree, for those of us who have just been watching this, who are just parents, who can see their young girls in the faces of Libby and Abby, and, you know, our heart maybe skips a beat when our girls say, "Hey, we're gonna go out and walk with friends." Because we know that there are people out there that will see our girls and maybe see targets instead of beautiful young ladies, that'll see victims instead of, the beautiful, wonderful people that we want to see grow into adults. And instead we have, this j- ego dance, and it's maddening. So, on that note, the world is full of shenanigans. In fact, shenanigans, and let's pull this up because this case has become a nuclear dumpster fire volcano. But we can all work to spread a little kindness. So, we can be really hard on ourselves. Say something kind to yourself. Say something kind to someone else. Look, it's a tough world. Say something nice to someone else. Just, it's rough out there. Be nice. Any hoozle, I'll see you guys in a little bit. I'm going to work on one more video for this, and then I will probably do something fun because I have been cleaning. Chaos cleaning, but it works. Have a wonderful day, guys. Bye.